Good afternoon, everyone. Welcome to the webinar on advanced issues on classification of goods. This is the second part in a two-part series that is being conducted by NITYA Tax Associates. In the first part, if you had attended, we had dealt with some basics of classification. And today, in this second part, we are going to deal with certain advanced issues that are faced by the industry quite regularly, and some issues that keep coming often before the court. So today's webinar, we have divided into four parts. Firstly, I'll be dealing with practical application of GIRs for determination of HSN classification. Secondly, in the second portion, we will be dealing with the basically the tests that are applied by various courts for classification, for determining arriving at the correct classification. Thirdly, we will deal with interplay of HSN with exemption notifications. So we will see whether the same rules that apply for HSN classification, whether they apply to interpretation of exemption notifications as well. And lastly, we will see what is the way forward. So we'll start with the first portion of our webinar, where we'll cover application of GIRs for HSN. Now, if some of you had attended our previous webinar, our partner, Mr. Dharnendra Kumar Rana, he had introduced GIRs and he had explained all the GIRs. So today I'm going to pick certain specific GIRs and deal with the discuss the issues and situations that are covered therein. So we start with Rule 2A, and for those of you who attended our last webinar, 2A deals with incomplete and unfinished articles and with disassembled or unassembled articles. So in case of incomplete and unfinished articles, that article is basically classifiable as a complete article in the same heading as the complete finished article, provided it has obtained the essential character of the finished article. Now, how will you determine whether it has already obtained the essential character of the finished article? So there are certain tests that have also been laid down by the courts. Firstly, and you will see whether this unfinished article has the approximate shape and outline of the final product. Secondly, we have to see whether it is convertible after some minor processing into that particular finished article only. So let's say if I have certain product which I can process into multiple articles, that cannot get classified as one particular single finished article by virtue of Rule 2A. It has to be such that it can only be converted into one single finished article, and only then Rule 2A will apply. So let's take an example. Let's say I have a rough forging, and that forging does not have anything on it, no cuttings, no markings, no holes drilled on it. Whether I can say that this particular forging, let's say it's in a ring shape, can I say that it is a forging for a gear and thus classifiable as an incomplete gear? Or I will say that this is a forged article of metal classifiable under chapter 73, 74, etc., which cover various kind of metals and their articles. So here the courts have held that if you are required to undertake a lot of processing before you can reach the finished article. For example, in the ring, if I have to drill holes, I have to make some markings, I have to cut the teeth, specific shape and size has to be, teeth has to be cut on it, and the finished article is going to be of a much smaller size than the incomplete forging that I'm dealing with, then in that case you cannot say that this is an incomplete gear. It will be classified only as a forged article. Forged metal part classifiable under respective metal chapters. However, let's say if gear has certain teeth cut on it, let's say those are not completely defined, but courts have held, especially in this case of Bharat Heavy Electricals Limited, the court held that if this particular product has been prepared, even though unfinished, as per a particular design and specification that is provided by the customer, and this particular article can only be used, converted into a gear of a particular size, shape, etc., then this article will get classified as an finished article by virtue of Rule 2A. Now, this is the case. Similarly, there have been multiple cases, it has come before Supreme Court, High Courts, and even larger bench, where they have dealt with different kind of forgings and applied different these particular parameters to arrive at whether these forgings become whether on these forgings Rule 2A is applicable or not. Next, the other kind of products that are covered under Rule 2A are unassembled or disassembled articles, meaning thereby that articles that are in CKD or SKD form. Now, for this, there are certain criteria. When will you say that this is not merely a component or a part, but actually an unassembled complete article? So, firstly, it should be that all these components, the only process that remains to be done is assembly. That assembly may be however simple or however complex, but that should be the only process. Further, such assembly can be done maybe by screws, by rivets, by welding, but it should only qualify as assembly, nothing more. So in secondly, in these cases, all these wherever you require only an assembly process, then if such components are in the correct ratio that are required for that finished article, then all these components can be said to be CKD or SKD. I will take an example. Let's say a watch requires 2 straps, 1 dial, and 1 battery. And if I'm importing, let's say 20 straps, 10 dials, and 10 batteries, I can say that I am importing 10 watches. However, consider that I am importing 21 straps, 11 dials, and 10 batteries. So this entire consignment of components cannot be said to be watches in CKD form. This consignment will then comprise of 10 watches in CKD form, 1 extra strap, and 1 extra dial. This extra strap and dial can be classified as per its under its own heading or part, depending upon whatever the applicable headings are. So in this case, certain issue that might come up is, let's say for manufacture of a watch, it always happens that 2 straps are always wasted. They always get consumed. So whether I can claim 2 straps as part of a watch in CKD form, or these two will in every case taken separately. So this is something that has to be examined and might be disputed. Another issue that comes up, that has come up before the court with respect to unassembled and disassembled goods is basically when you're importing in multiple consignments, different consignments. When, let's say, you're setting up a new manufacturing, so you import certain goods in separate, certain components, parts, etc., in multiple consignments. So here there is a landmark case in case of Sony India, wherein Sony was importing different parts and components pertaining to televisions in multiple consignments. In fact, as many as 94 consignments were disputed by a department, and this import was done over a period of 22 months. So all of these 94 consignments imported over a period of 22 months was disputed by department. The classification was disputed as parts and components. The department alleged that these are actually finished color TVs in CKD form. So you can they said that these are not merely parts and components, and Rule 2A will apply, and you will classify it as a finished TV and pay a higher rate of duty. In this case, the court held that you have to see whether, firstly, all these consignments, it is important to see whether these consignments are presented together. So it had covered a period of 22 months. So when it is spread over such a long period, and even the components, the ratio wasn't accurate with respect to manufacture of color TV. Certain components were there, some were not there. So in such a case, the court said that you cannot club all of these consignment together and take them as color TVs in CKD form. Conversely, it has also been held by the court that where certain parts were imported in multiple consignments through different companies, the court has looked through such a transaction and it has clubbed all of these together and held that these are actually finished articles in CKD form. This would happen only with basically depending upon the facts, peculiar facts of every case. If there is, let's say, if court perceives fraud, that artificially the consignment has been split up into different, basically different import quantities and being imported to different companies, but the entire thing comes together in a container, has been marked similarly. So court can look through such a transaction. In certain cases, it can club all of these together consignment, even when coming separately. Another there are several factors where even though in Sony India, the court said that all of these have to be presented together in order to be in order to qualify as CKD, SKD consign articles. There are certain other factors also that have to be considered, and depending upon result of each of these factors, in each case, you might arrive at a different result. So that can be how you're placing your order. Let's say you've placed an order for the complete article in CKD form. Secondly, you have to see how many sets that complete, how many sets that consignments make. Let's say I have ordered, if certain product requires quantity two of one article and four quantities of another, and I have imported in the same ratio of 2:4, then in that case, the court might hold that these are actually CKD articles and not different parts and components. And accordingly, it might be assessed and subject to custom duty. Now, Rule 3 is basically applicable when for any reason, whether by application of Rule 2 or any other, you have arrived at more than one headings that may be applicable for your product. So in this case, how do you sort out that which heading is more applicable? Where do you classify a product? How do you pay a duty? So for that purpose, Rule 3 is split into three parts. Rule 3A, that is the first one. It basically provides that any heading, if there are two headings applicable, then heading which more specifically describes a product, that will be preferred over a general description. So let's take an example. Let's say we have a machined part made up of metal. It has made according to specifications of that machine, and it is meant only to be fitted into that machine. Then in that case, whether it will be an article of metal classifiable under general chapters, that is 73, 74, etc., or you will classify it as a part of machine. So in this case, if subject to, of course, the chapter notes and section notes that are applicable for that particular heading, depending upon that, if I can arrive at two different headings, that is part as well as general articles, then I will say that this is more specifically covered under parts of a machine rather than under a chapter which covers the metal and its article. So for Rule 3A, there is no hard and fast rule. It is very subjective. Classification itself, it's very subjective, and there is no one rule which you can follow to arrive at which heading is more descriptive. Sometimes it might be more descriptive by the nature of the product. Sometimes it might be by use. So there are different criteria. So one issue which had come before the court was the case of Videocon, wherein the classification of LCD panels was in dispute. In this case, the court had actually gone to Rule 3A, and they had said that when LCD panels are being imported and these LCD panels are going to be used as parts of television or audio sets, then a heading which specifically covers LCD panels, which falls under 9013, that heading would be preferred over a general heading which covers parts of televisions or audio sets. So the code said that a entry which by name specifically covers LCD panels, that would be preferred over a general entry where you might cover all and every part of television sets from let's say from panels, the body of the TV, the front glass, etc. So here in this case, court had expressly applied Rule 3A and held that your classification has to be done on the basis of more specific entry. Similarly, for food industry, this becomes relevant. For example, in case of, I'll just take an example of potato wafers. Now, potato wafers might be classifiable. There may be many headings which are applicable. There is one heading for potato. There is another heading for processed vegetable, and then there is a residuary entry which covers all edible preparations that are not covered anywhere. So in this case also, we will see which is more specific. Uh, the residuary entry being general in nature cannot be preferred over a more specific entry which heading which covers processed vegetable. So when potatoes are cut into slices and fried, and frying is can be covered as a process, these would qualify under chapter 20 as processed vegetables and not under the residuary heading of chapter 21, which covers all the residual food articles. Now, coming to the next rule, Rule 3B. This is the second part of Rule 3. This provides that when, as per Rule 3A, you're unable to arrive at a specific heading, and you have, it's a mixture of different components, and you have more than one headings which are applicable. In that case, you will see what component gives the essential character to the entire product being classified. Now, how will you decide what gives essential character? There are various factors and no fixed criteria. This will vary from case to case, from product to product. What are the past jurisprudence, how it is perceived. So it might be on the basis of weight, it can be on the basis of volume, it can be on the basis of value as well. It can even be on the basis of a role that a particular component plays in that particular article. So this is again, as I said, classification is very subjective issue, subjective matter. For each case, you have to independently determine which factor you feel is more applicable, which is more relevant, and accordingly you have to arrive at what is going to determine the essential character. So here I'll refer to a case in the case of judgment in the case of Bakelite Hylam Limited. Here there was the classification of laminated sheets, decorative laminated sheets was an issue, and this product by weight was primarily it had paper and which was maximum in weight, and other than that it has certain other components also which included resin, which is basically plastic. So even though weight by weight paper was predominant in this case, the court went into the nature of laminated sheet, said that they are used basically for their strength, and the strength to that sheet is being provided by the plastic resin that is being used. So classification shall not be done according to the according to paper component, but according to the plastic component. So here they went into the essential character not on the basis of weight, but according to the role that that component was playing in the final product. Now we come to Rule 3C, to which our poll question also related. So most of respondents said that rule whenever there are more than one headings, the last in the numerical order can be preferred over any other. That is true, but that is subject to conditions that this is the last rule 3C. So this 3C will apply only when you previous rules are not applicable. So if you are unable to arrive at the specific heading, which is more specific, If you are unable to arrive at the essential character of the product, only in that case, when you feel that there are two headings which are equally applicable, equal in weight, then you will come to rule 3C and classify your product according to the heading, in the heading which occurs last in numerical order. So this is not a rule that will become applicable in all cases. It is subject to the condition that 3A and 3B are inapplicable. Only in such cases you can go to 3C. In no other case you can go to 3C. And so we'll take an example also for this. The court was dealing in this particular case of Anutham Exim Private Limited. It was dealing with classification of a carbonated beverage which had fruit juice as well in it. So in this case, the court arrived at the conclusion that in this particular beverage, carbonation as well as fruit juice are equally important. You cannot say that carbonation is providing it the essential character, nor can you say that the fruit juice is providing the essential character. So in this case, the court held that since both are equal in weight, both are equally applicable, this product has to be classified on the basis of the heading that is occurring last in the numerical order. Now we move on to the next portion of our webinar. In this next portion, we are going to see some tests, evaluate some tests that are employed and developed by the courts for determining classification. The first and the most common test that the courts usually apply is the trade or common parlance test. So what does common parlance mean? It means you have to see how what is the meaning of the product that is generally understood in a particular by the common people and in a particular trade or maybe in a class of business. This test is basically you have to adopt it when in statutes nothing is clearly defined. So there is no statutory definition given. And if the statutory definition is given, of course, that has to be preferred. But if there is no definition provided in the HSN or anywhere else, in the chapter notes, in the section notes, or in the HSN explanatory notes, then you can use the common parlance test, see how the product is generally understood, and arrive at the classification. So, common parlance test, if you see, is quite often used in case of food articles in the food industry because in a lot of cases there is no technical definition of a product. A lot of food articles, it come one let's something being called, let's say, an ice cream might cover a large wide variety of products. So in this case, courts generally see how it is commonly perceived and then arrive at classification. So we'll take the example of ice cream only. There was a case before there was this particular case of Connaught Plaza. Here the issue was basically the soft serve that is served in their outlets, whether this will qualify as an ice cream or it will be a milk product. So the court said that basically you have to apply common parlance. You have to see how it is understood, whether this soft serve is generally understood by the consumers as ice cream. When a consumer is walking into an outlet for ice cream and when he gets soft serve, whether he believes and perceives that he's having an ice cream. If that being so, in that case, such product should be classified as an ice cream because there is no technical definition of ice cream. There might be under another law, but that cannot be borrowed for the purposes of classification for under excise. This was under the earlier regime. So you in this they went into the common parlance test. They said that common parlance test is an extension of the general principle for interpretation of statutes. By examining how a particular term is perceived, you are trying to basically interpret the intentions of the lawmakers. So it is an extension of that rule of a rule of interpretation of statutes only, and how it is generally understood in the market, in the trade, let's say, that is relevant. And when, like I said, if there is no statutory definition, rigid technical meanings are to be avoided, and common parlance test is to be applied. Another case that was there in before court was of Sri Baidyanath, where classification of tooth powder was in dispute. In this case, uh, the dispute was whether it qualifies as a medicament or it qualifies as cosmetics. So the court held that it is generally and commonly perceived by the consumers as cosmetic, and tooth powder is also specifically mentioned there. So it will be classified as a cosmetic and not as a medicament, irrespective of how you market it. So the court, in fact, even said that, by you can't see how marketing is done. That is not the only, that can't be the relevant criteria. You might market it in a certain manner, but if the perception in the mind of consumer is different from that how it is being marketed, then you have to see the perception and not the marketing part. Next, the which is a test which is often applied by the court is a technical meaning test. Like I said, the common parlance test is mostly quite often applied in case of food articles. Technical meaning test is basically applied in case where there are some technological or scientific expressions and meanings are attributable. So this is especially true, let's say, in case of chemicals, chemical industry, machines, whether mechanical or electrical, automobile industry, instruments that are covered under Chapter 90. So here, because there are different products that are covered under different headings, and they might technically vary from each other, and that difference in headings might be only technical. In that case, you can't see how it is commonly perceived, and common parlance test cannot be applied in such case. Here you have to go into the technical meaning. So before the court, there was a question regarding classification of building stones. Uh, so there, because it was described in a technical manner, that how that material is to be classified, that material, then they said that even though commonly it might be perceived as something else, you have to see technically what it means and arrive at classification based on that. So when the tariff entry only envisages that product has to be a technical product, and the heading covers certain technological or scientific product only, then you have to go to the technical meaning of the product. Another test that is employed by the courts is end user test. So it basically it is quite self-explanatory. This test basically determines, based on this test, classification of goods is determined on the basis of how the products are being used. What is the end use of the product? So this test becomes relevant when classification is heading covers a product based on the function of the goods, and not just by description of the good or the components or the composition of the goods. So when function gets is important, then you have to see end use. So let's say there is a machine which provides cool water, chilled water, and that is basically it is end use is only to provide chilled water. Then in that case, even if it is incidentally providing some hot water also, it will be classified as a machine of providing chilled water under under the heading covering refrigerators, etc., and not as a heat pump, even though it might incidentally be producing certain hot water also. And this becomes also relevant in there are certain headings under a tariff where, for example, the heading covering adhesive. So there, the criteria of being for qualifying, one of the criteria for qualifying as adhesive is that it is put up as adhesive. So irrespective of composition, even though it might, if you just go by composition, it might get classified under another heading, another chapter for that matter. But if something is being used as adhesive and it is being put up as adhesive, then in that case, that product will, the end use of the product, since it is being used as adhesive, that will become relevant and accordingly it will be classified. Now we come to the third part of our webinar. Here I will deal with the interplay of HSN with exemption notifications. Now, as you must be aware, our HSN system, our classification is basically based on the harmonized system of nomenclature that that has been laid down by the WCO and to which India is also signatory. So that has been borrowed by us. And this HSN is not very fluid. It does get changed, but more or less it is fixed. There are changes which are made to it, but as compared to an exemption notification that are issued by the government, which are much more fluid, the HSN code is quite rigid. So here, when all the tests that are there under the GIRs, the different rules that we use to interpret HSN, whether I can use those rules to interpret exemption notifications also? In which cases are there certain cases where I can use those rules and certain cases where I cannot use those rules? So this has come up before court and we will just proceed with that. So there might be certain notifications which refer to the HSN. They provide exemption by referring to the HSN. And there might be certain notifications which do not refer to the HSN. They only specifically mention a specific product and no reference to the HSN is made. So in that case, where HSN is mentioned, GIRs have to apply, and even whatever classification you have arrived at on the basis of GIR, that will also apply for exemption notification. So the same thing would apply for notification. Whereas if it does not refer to notification, classification and exemption notifications might lead to different results. So you might classify a product as product A, but for exemption notification, for availing exemption, you might fall under a particular class of product that is defined there in the notification itself. We will just see an example with the judgment of a court. So this is a Supreme Court judgment in the case of Maestro Motors. In this case, the court was dealing with two cases, one of Maruti and one of Maestro, and both of them were manufacturing motor vehicles, motor cars, and different components and parts were being imported as motor cars and CKD form. So in both the cases, for the purposes of HSN classification, by application of Rule 2A, which we just covered, which covers disassembled and unassembled product, for purposes of customs classification, the court had applied that rule and said that this all these components and parts are classifiable as motor cars in CKD form, and accordingly duty has to be paid. Now in these two cases, there were separate exemption notifications which were under issue. So in case of Maruti, the notification did not refer to any HSN. It only said that parts and components of motor vehicles which may be in CKD or SKD packs. So here, even though for the purposes of classification, they were being called motor vehicles, motor cars, for availing exemption, the court held that if it is for part, you will qualify as parts and components because there is no reference to HSN. You are still part and component, but by virtue of 2A, for customs, you are being classified as a complete motor vehicle. But since the exemption notification does not make any reference to the HSN classification, you can, and since it specifically covers CKD and SKD packs, therefore, Maruti can avail this exemption and classify it and take it, avail the exemption which are available for parts and components. Now, conversely, in the case of Maestro Motors, The exemption notification was slightly differently worded. That notification provided exemption to parts and components of motor vehicles falling under Chapter 87. So in this case, the court was of the view that since here the exemption notification has specifically referred to a HSN classification, in this case, now you cannot say that for classification, I will take it as a motor car, and for exemption notification, I will take it as a part and component. When under for classification under Chapter 87, you have already qualified as a motor car. Now you cannot go and say that for the purpose of exemption notification, I will qualify as part and component under Chapter 87. So depending upon how the exemption is worded, you have to see how a product will be classified, whether the exemption is applicable to a product or not. In this case, there are certain other examples also of interplay. For example, in case of automobile sector, uh, there are several parts there are several components that are used in automobile industry that might not become parts per se, which are classifiable under Chapter 87. They are independently some other machine, let's say engines, motors, etc. So all of these are classified under their own headings of Chapter 84, 85, or any other. So in this case, assessees have been correctly classifying it as a product of another chapter, and if there was any exemption available, they were correctly claiming it. Now the government for giving effect to their intention, basically of not providing benefits to automobile parts, they have specifically introduced entries now under the exemption notifications, whereby they have excluded those goods which are suitable for use in motor vehicles. So even though you might not be falling under Chapter 87, you will be falling under Chapter 84 or 85. But since you are suitable for use in a motor vehicle, exemption cannot be availed by you. So now by this change, they have kind of affected the exemption notifications that could be availed earlier. Another issue that might come up in case of exemption notifications is that sometimes a notification mentions headings, and before the headings, it gives a description. A lot of times you must have seen under Chapter 84, 85, it covers a machine and it also covers its parts under the same heading. Now, let's say while providing exemption, the notification mentions the heading, not the subheadings or the specific 8-digit under which the part is covered. It will mention or any other specific 6-digit or 8-digit under which any other product is covered. It will give 4-digit. Before that 4-digit, it will mention the machine, but it fails to mention parts. So in this case, an issue might come up that whether in such a case, when everything is the same except that the part is not mentioned, whether such an exemption can be availed with respect to parts or not. Whether such a notification covers the entire ambit of that particular heading, everything that is covered under the heading, or only so much of the portion that is mentioned, and if parts are not mentioned, parts cannot be eligible for this exemption. So now we come to the last part, the fourth part of our webinar, the way forward. Now, for those of you who had attended a last webinar, basically for classification, the way forward is the same. It remains the same as that was in our last webinar. So you have to basically undertake review of your classification for both domestic and imported goods based on these GIRs. On chapter notes, section notes, past jurisprudence, Indian jurisprudence, foreign jurisprudence can also be taken help of. And this review is basically also relevant in case of import when you're availing FTA exemptions, because all of those exemptions are available based in reference to a particular tariff heading. So it is only if you qualify under that particular heading and under the description that only then you can avail that benefit. So classification for that purpose is very relevant. In case there is a revenue neutral transaction and there is some dispute with the department, you can pay tax under protest and later claim refund. This we had discussed last time also, that in case where ITC is available to the customer, you can adopt a conservative position, non-confrontational position with the department, and even pay duty at higher rate where ITC can be availed by the customer. So in this case, even though a classification might be under another heading to which a lesser rate is available, or exemption notification, might you might feel correctly that it is available, but the department might dispute the same. If IT is available, you can adopt a conservative position. And also, filing of representation, we had discussed last time also, that in case you feel that certain issue needs to be addressed at the policy level, then you can file representation before CBIC and GST Council. Thank you so much for joining us today.